Welcome, everyone. We are about to get started. My apologies for the slight delay. We were switching forums. There was a meeting preceding this one, but warm welcome. Thank you so much for joining us in this discussion. As you'd see, this is quite an open concept. So the objective is to encourage involvement, participation, certainly discussion to follow after each of the presentation. As you see on the screen, I'm joined by my colleagues, Dr. Zhang Haihong, Dr. Colin Mitchell, and Professor Yann Joly. So all very experienced and distinguished scholars from leading research institutions. And we are very keen to learn of your thoughts on this very important issue. I thought I'd start off with a bit of introduction about the situation in Hong Kong. I'm very happy to say that we're joined by some of our research colleagues. They are in the audience, and including some of our colleagues, if I may say so, from the Hong Kong Genome Institute or the Hong Kong Genome Project. So very much welcome your thoughts in relation to, of course, the sharing of genomic data. So I'm reminded by my colleague Jane. So of course, I'd like to thank Miss Jane Oh, who's our center manager. So she has been very helpful in getting the entire system set up. So she has also kindly reminded me to remind all audience that if you do not want your image to be captured or do not provide consent to that effect, please do switch off your video. But otherwise, you are very welcome to be visible. That would be very nice to, in a sense, see your image on the screen. But choice is entirely yours. And of course, we very much welcome your thoughts and participation following this. So let me start off. If I haven't introduced myself, my apologies. I'm the co-director of the Center for Medical Ethics and Law that's based in the University of Hong Kong. So let me just quickly share some thoughts about the situation in Hong Kong. So some of you may already be familiar, but in case you're not, then this particular presentation may be helpful. So let me just bring the slides up. I hope it's clear to everyone. Okay, just put it in presentation mode. So we are, of course, very keen on this particular initiative, as I hope you will be too. If you're not, then of course we'd love to hear your views or criticism of this movement. It's not perfect. There are some limitations, but in case you're wondering what the Open Science Initiative is about, this was mentioned in the abstract to this particular workshop. And I draw the definition from a very recent UNESCO document issued in September last year. So it speaks of open science as essentially an inclusive construct that combines various movements and practices aiming to make multilingual scientific knowledge openly available, accessible, and reusable. And what's important for the purposes of this webinar is the goal of increasing scientific collaborations and sharing of information for the benefit of science and society. We are, of course, here focused on a specific type of information, and that would be genomic or genetic information. So in Hong Kong, the key legislation that speaks to the protection of personal data is the Personal Data Privacy Ordinance. And in this particular ordinance, in Section 2 in particular, it defines personal data as data that relates directly or indirectly to a living individual, from which it is practicable for the identity of the individual to be directly or indirectly ascertained, and that is in a form in which access to or processing of the data is practicable. So data is any representation of information, so including opinion, and in any document, and it should, of course, include a personal identifier. So it must relate to a data user. And if these particular requirements are met, then, of course, the data collector or user will have to comply with the data protection principles. You'd see on the slide that there are 6 data protection principles set out in the statute. So these relate to collection or purpose as well as the means by which such data is to be collected, on accuracy and retention. So that's data protection principle 2, DPP, which is abbreviation for data protection principle. So DPP 3 speaking to use, 4 speaking on security, 5 relating to openness, and 6 access by the data subject to information that is collected about her or him for that matter. So that's what the Personal Data Privacy Ordinance in Hong Kong provides for. But what's interesting is that unlike the GDPR in Europe, we'll hear more about this from Dr. Mitchell, you'd find in the GDPR there is an explicit reference to genetic data, and the use of sensitive genetic data is prohibited unless an exception applies. So we'll hear more about this, as I've mentioned, from Dr. Mitchell. But I mentioned this here because in our statute here in Hong Kong, that there is no explicit mention of genetic data. But what's very helpful is that in a response to the media by the Privacy Commissioner here, there is an indication that genetic data could be personal data for the reasons that you see on the slide. In response to the query from the media, and that's specific to a genetic company. So you'd see here the second bullet point, right, that if a genetic company collects genetic information, then it is required to notify individuals concerned upon collection of genetic data from them regarding, amongst others, as you see here, the purpose for which the data is to be used and the classes of persons to whom the data may be transferred. So of course, this relates to data sharing that we will be discussing more of. And with respect to the use of genetic data, such companies are required not to use collected data for a new purpose, which is not directly related to the original collection purpose, without the express and voluntary consent of individuals concerned. Of course, this would be the requirement under Data Protection Principle 3. What the Privacy Commissioner went on to indicate is that these companies are also required not to retain the genetic data for longer than is necessary to fulfill the purposes for which the data is or is to be used, and to erase the personal data that is no longer required. So this would be in keeping with DPP 2 as well as Section 26. Of course, this is in relation to the collection of genetic data for, well, testing or for some sort of evaluative purpose. So that essentially was the nature of the question that was presented to the Privacy Commissioner. So not quite in relation to research, or at least not specific to that, but pertinent in terms of research entities that would collect genetic data for research use. But what's important to highlight is that the statute under Section 62 does provide for an exemption. Of course, this would be in relation to DPP 3 relating to use in particular. You see here that personal data, including genetic data, as interpreted by the Privacy Commissioner in its response to the media, if it includes genetic data, then it would be exempted from this particular data protection principle if it is used for preparing statistics or carrying out research. So data is not to be used for any other purposes. Of course, if it's collected for research, then essentially just limited to this particular purpose. But what's very important to highlight in Section 62 is that any sort of reporting of findings, so the results of the research that may subsequently be made, should not identify data subjects or in fact any individual, so thereby constituting, of course, a personal data as we understand it in a conventional sense. So where the limits are, there is as yet no specific guidance on this, although we do have these general provisions to refer to. Additionally, of course, that's in relation to the 2017 media inquiry that was presented to the Privacy Commissioner. The Commissioner also indicated that there is this particular guidance, again, not specific to research, but there are some important insights that we could get from this particular guidance document. So sensitive biometric data, as you see here, could include DNA samples and therefore by extension, genomic information, so or genetic data. So where such use is concerned, then there are a number of considerations that must be taken on. So you're very welcome to look into this particular guidance document because it speaks to the need for privacy impact assessment and the avoidance of the function creep. So essentially that would be to give effect to the use limitation set out in DPP 3. However, of course, as we have seen in section 62, right, the exemption may apply provided that when we think about the reporting of results, right, that no particular individual will be identified as a consequence. But short of that, or if it does not fall into the exemption, then all of the usual requirements set out in the Personal Data Privacy Ordinance will apply. And the considerations set out in this particular guidance document will be particularly important to take into account. So that's the current situation in Hong Kong. It's a very quick overview, but I'm very happy to take some of the questions on in discussion and perhaps comparatively as we hear from our colleagues in 3 other important jurisdictions. So we begin with our colleague across the border from us on mainland China, and that's Dr. Haihong Zhang. So Dr. Zhang is the office director, as you see, of Peking University, clearly a world-class research institution, along with the University of Cambridge and McGill University, of course, our institutions of our 2 other speakers. So she heads the Human Research Protection Program of the Health Science Center at Peking University. So she's going to speak to us about a very important development on the mainland, and that's the implementation of the Personal Information Protection Law. As we'll hear very shortly from Dr. Zhang, there isn't a specific provision on research, so it will be very important to think about what implications there are in terms of the sharing of data, particularly sensitive genetic data for the purposes of research. And of course, what's also very helpful to note is that the provisions in the Personal Information Protection Law on mainland China are broadly similar to those of the General Data Protection Regulation, the GDPR, of the European Union. So, so very nicely followed by Dr. Mitchell's presentation after we hear from Dr. Zhang. So with this, Dr. Zhang, it's over to you.
Thanks, Kevin. Then please allow me to share my slides.
Okay, so sorry, let me stop share. So there you go.
Hi, everybody. Glad to be here, and it's my great honor to join this discussion. For this part, I will share some ethical perspective on the implications of the Personal Information Protection Law in China. So in my presentation, I will touch on the 4 parts. So, sorry. Firstly, I will briefly introduce the regulatory framework and have a closer look at of the key provisions of the Personal Information Protection Law. Then, as Kevin mentioned, there's no specific space for research in this latest Personal Information Protection Law. Then I will have a closer look at the ethical governance framework of human genetic research in China. So based on this, we have witnessed a very quick evolution, I think, in our legal system regarding to protection of personal data protection. As you see in these slides, in recent 3 years, we have very significant involvement of our legal system. And the most recent one was the Personal Information Protection Law, which was officially effective on November 1st, 2021. And we also discussed human genome research today. So when we're talking about human genetic research, it also very close to the regulations on the management of human genetic resources in China. At the same time, for such kind of research that involving human subject, we have to assure the compliance with the ethical review guidelines of our biomedical research involving human subjects. So under this regulatory framework, let's have a closer look at some key provisions that very close to our discussion today. As we mentioned before, regarding to the definition of personal information, we can see that the personal information definition in our latest law is very close to the GDPR in the Europe, and it mentioned to all kinds of information that related to the identified or identifiable natural persons. So here, anonymized information is not considered as personal information according to this law. And there's a lot of keywords in this law mentioned about personal information processing. So when we talked about processing here, we can understand it more broadly from the collection, storage, use, and the transmission or transfer of the personal information. Based on such kind of the definition of the personal information, 5 general principles were set forth by the law. First, it is required that the processing of personal information, no matter what kind of purpose, must be legal with appropriate purposes, with necessity and integrity. The purposes of processing such personal information must have clear and reasonable purposes. All the actions involved during the information processing must least affect the personal rights and interests. At the same time, transparency and data quality were affirmed in this law. Also, the accountability of different stakeholders and the safety requirement regarding the storage, transferring of such kind of information also reaffirmed. At the practical level, 2 things were confirmed by this law with compliance. The first and foremost is the individual informed consent of the subject. So on the other hand, is specified in this law, all the actions or any processing of personal information must be compliant with related laws and regulations, including this personal information protection law and other regulations in China. With this basic principles set forth, you know that informed consent is always as one of the most legal and ethical requirements. So for processing personal information, the law just required the data subject must be informed and to make sure get their voluntary and specific consent. Such consent must be obtained in advance before initiation of the data processing. And during the informed consent process, detailed information must be provided clearly and in an understandable way. So the information must be provided, including the name, contact information of the data processors, and why they should do such kind of personal information process, what kind of method, and what kind of information, as well as how long the data processors will keep such kind of information. At the same time, the data subject must be fully informed about their rights and possible procedures for claiming such rights. So besides the principles set forth and the consent requirement, there was a specific chapter, that means chapter 3, to make it clear that the rules for cross-border provisions of personal information. So this is generally applied to all the activities that involving cross-country or international sharing of personal information, not only in research, but also in other fields. Basically, at least 4 requirements must be satisfied to make the cross-border provision of personal information legal or acceptable. First, that the provision must pass the security assessment organized by our National Cyberspace Administration Department. The second is the personal information protection must be certified by a qualified professional organization. And the third requirement is the both parties, domestic processors and the international recipient of such information must sign contract, and in which the contract must specify the rights and obligations. Regarding to more detailed about this personal information, as long as they might involving any human genetic resources, including biospecimen or data, such kind of cross-border provision should also comply with our regulations on the management of human genetic resources too. So additional consent requirements were also set forth. And one of the most important part is the international recipient, their contact information, their name or which organization, such kind of detailed information must be specified and clearly inform the data subject. And besides the information required, the personal information law also set forth that such kind of separate individual consent must be guaranteed. So here, the separate individual consent is a little bit different from the general consent we mentioned as usual. So separate individual consent maybe have higher requirement, like separate category must be made to make sure the data subject have their right to say no or yes, specifically to the international provision of their personal data. So after having a close look at the key provisions set forth by the latest law, we can make sure that the human genetic research also have certain kind of ethical governance framework in China. We know that since late 1990s, China has developed our own ethics review system. And now most of the ethics review were conducted at institutional level. So when we're talking about regulatory requirement, when conducting ethical human genetic research, we have 2 levels of administration. One is at the institutional level, we always mentioned as ethics review and informed consent requirement set forth by the ethical review guidelines. And another one is at our national level. Mostly, the Ministry of Science and Technology is the main responsible body then to give such kind of administrative permission or application of records filing according to the regulations on the management of human genetic resources. Firstly, at institutional level, all the human genetic research must apply for ethics review and get approval and get the subjects informed consent. After the effective of our personal information protection law, we have to make sure the compliance of the research or investigators. On the other hand, we can see we have some main challenges. Even after 30 years navigation in the ethics review policies, we still have a lot of concern about the ethics review quality when relating to the human genetic research. it would be very interesting. We always have very interesting discussions during our ethics review board meeting when we discuss such kind of risk-benefit assessment and what would be the acceptable risk control measurements. And now recently, more attention are paid to how to avoid uninformative research. So the ethics review members pay more attention to the review of the scientific and social value of such kind of research. And from another perspective is that I think in all over China, many hospitals and academic institutions have developed or set up their own ethics review board. However, because of the variations of the capacity building of those different institutional review board or ethics review committees, so the ethics review quality in general, not specifically for the human genetic research, was always a big concern for us. On the other hand, when talking about informed consent, it becomes more complex. So as we can see in this slide here, we have many different kinds of consent. So the investigators, even sometimes our ethics review members, might be confused about the different requirement of the different kinds of consent. For a particular research, specific consent must be obtained in advance. And according to the Personal Information Protection Law, separate consent for international transfer or data sharing must be obtained in advance. Another, once when the research that might involving preservation or the possible future use of the data or specimens, broad consent must be taken place. So there's a little bit frustrated, I guess, for all the investigators. Then another main challenge for us is for those data would be collected in the future, even though the consent requirement is complex, it's still workable. However, for those existing data, so when they were collected, usually low valid informed consent were get. So for those how to use such kind of existing data and whether IRBs can make the waiver of consent, just because according to our current ethical review guidelines, the hands of IRBs are tied actually. So we had a lot of argument and a lot of discussion to discuss what kind of waiver of consent for using existing data is acceptable. Now, we do not have a concrete answer yet. So regarding to the national level administration, we call it Human Genetic Resource Administration. Here, the human genetic resources mentioned both biospecimens and data. Such a national level administration can date back to 1998. About 3 years ago, we had the updated version of this regulation. According to the 2019 regulation, we can see that the scope of this administration has broadened. So from the collection, preservation, international collaboration, and overseas transfer or data sharing must make sure the compliance with this 2019 guidelines. And the detailed operational guideline just finished the first round public consultation yesterday. So for such kind of concrete measurement at the institutional level, always investigator should apply for such kind of administrative permission or records filing to the Ministry of Science and Technology. So 4 kinds of activities that relating to human genetic resources must apply for administrative permission, and another 2 must apply for records filing. Actually, records filing, we can consider it certain kind of expedited procedures it would be much easier and quickly to get the approval. So for the collection more than 500 cases, human genetic resources, the administrative permission were required. If the investigators or the research team would like to preserve such kind of biospecimen or data for future research, they need to apply for the preservation permission. And for those international collaboration and overseas transfer of genetic samples or materials too. So for the other two categories that needs to apply for records filing is certain kind of international clinical trials did not involving materials export. And the second category is the data sharing or human genetic information or data sharing or international provision. We need to apply for the records filing. Even though the administrative permission or the records filing have certain kind of expedited procedures, there are a lot of challenges and different voices from all the different stakeholders. Because of this, were additional procedures after the ethics approval and institutional level. And also, even the 2019 regulations are still very general. Low operational guidelines are yet in place. So different stakeholders, particularly the research team or investigators, were confused. They are not well informed about those regulatory requirements yet. And the result, a lot of back and forth communications and a lot of time were consumed for the preparation of application documents. So when you're talking about the application of such kind of human genetic resource administration procedures at the institutional level, maybe the most voice you will be heard is the time-consuming and low efficiency. However, compared to such kind of identified challenges, we must look at the positive side. Just because many actions are taking process, are in process, and people are making the effort. First and foremost is more detailed regulations, ethical guidelines are in the process. Once we do believe that when we have certain kind of updated regulations or ethical guidelines, it will be more practical to conduct better ethics review and national level administration of human genetic resources. And on the other hand, in recent high-level documents or in recently, everybody is agreed that the institution should be more active and more supportive to support and strengthen the capacity building of their ethics review committees to make sure much higher quality ethics review. And on the other hand, to be more supportive to provide continuing ethics training and ethics consultation for investigators to make them to be better informed about such kind of ethical and regulatory requirement. And mostly we are recognizing that more communication are needed, either among the IRBs and the investigators, among different institutions, and in China and abroad. Just because of such kind of communication, we can know better with each other and we can know better with the different legal system. So based on this, we can have more respect to culture and to make sure we have certain kind of compliance when we have our international collaboration to conduct such kind of human genetic resource. So with that, I will close my presentation here. Thank you.
Thank you so much, Dr. Zhang. So certainly a very encouraging note ending off there. And I do hope that discussions in this webinar is going to help contribute to the process. So thank you so much. With this, I'd now like to hand over the forum to Dr. Mitchell. So Dr. Colin Mitchell is the head of humanities of PHG Foundation, very close working collaborator of our center. So PhD Foundation is part of the University of Cambridge, and Dr. Mitchell will be sharing with us his thoughts on related provisions in the UK and in the European Union. So over to you, Colin. Thanks very much.
Thank you very much. As you just said, Calvin, I'm going to be speaking on the impact of the UK and EU General Data Protection Regulation on international genomic data sharing for research. It's a privilege to be here. As Dr. Ho said, I am Head of Humanities at the PhD Foundation, and we are a health policy think tank based in Cambridge, UK. And our team have a particular focus on the policy, ethical, and legal or regulatory issues relating to genomic and other technologies, which means a considerable amount of work on genomic data and regulation. That's part of the background to me being here today. So what I would like to do in the short time I've got is try to provide a quick overview of the general way in which the UK and EU General Data Protection Regulation, and I'll explain the difference between those shortly, impact genomic research. What I want to focus on is the particular challenge at present in relation to international transfers of personal data in the research context, and outline really the current state of play in that area, and some potential mitigations or solutions that have been posed in the literature or in policy more generally. The background to this is a considerable piece of research we carried out in 2020 on the impact of the GDPR on genomic healthcare and research in the UK and Europe, funded by our data protection regulator in the United Kingdom, the Information Commissioner's Office. I'm flagging this for two main reasons. One is if you are interested in some of the depth of detail in relation to what I'm going to talk about, you will find all of it here in a comprehensive form in a freely available public report. And I just want to flag that although this, is a piece of work that was carried out 2 years ago now, the vast majority of the analysis is current to the present situation. But I'll talk through some aspects that have been updated since in the talk. So I think in a slightly beneficial way, given Calvin's initial outlining of the position in Hong Kong, I'm just going to give a quick description or overview of the European Union's General Data Protection Regulation and flag a few points of interest in the research context. So this is a general regulation that's been in force across the European Union since May 2018. It's important to note that it's based on the fundamental right to data protection that's recognized in the European Union's Charter on Fundamental Rights and Freedoms. And so the aim of this regulation was particularly to strengthen the law in relation to data protection, but also to harmonize how it applied across the European Union and to smooth out as many divergences in different national approaches across Europe as possible. The other really important thing I think to note about the European law is that it applies to all sectors and forms of processing in general terms in the same way. So this means that the same essential rules, principles, requirements, and obligations apply to digital marketing or commercial activities in the same way as they do to health or genomic research. There is some difference, and I'll mention in a moment some of the special provisions that relate to research, but in general, the challenge with this regulation is that the rules are designed to apply to all sectors. There are some other key features that have brought the GDPR to particular prominence, including its new and high enhanced level of fines, which has caught the attention of many companies and the media worldwide. Okay, so I said I would explain the position of the United Kingdom General Data Protection Regulation. Well, the position is that the UK, following its exit from the European Union in 2020, incorporated the GDPR, along with many other areas of European law, into our own legislative framework. So it's simply transposed almost verbatim as the United Kingdom GDPR. At present, there are virtually identical provisions, in particular relating to international transfers, as I'll discuss shortly. So for the purposes of today's talk, really, I don't think it's necessary to distinguish the detail of the two. But going forwards, it is likely there will be differences between our legal regimes. At present, the UK has also secured something called an adequacy agreement with the European Union, which allows free flow of data between the EU and the UK to continue until 2025. And this in some ways is very important because it implies that the UK is not likely to diverge significantly in the short term, although the government has proposed some plans to do so. I want to really quickly just run through some of the central elements of the GDPR, and Dr. Hoag very kindly did a parallel at the start of this session, which I think I can use here, because it's apparent that the GDPR applies to a very similar definition of personal data. So this means information relating to an identified or identifiable natural person, either directly or indirectly. And we know that to determine whether a person is identifiable, you take into account the context and all the means reasonably likely to be used in a context for identification. I think for today, the point I'd like to emphasize is that this is a potentially very broad scope of personal data. And in particular, when you're considering genetic or health data, it is frequently likely that such data will constitute personal data. The other element in terms of the fundamental scope of the regulation is of particular interest today, I think. It's the territorial scope of the GDPR. As a fundamental rights regulation, it doesn't seek to limit its application to the EU. In fact, there are two ways in which the GDPR applies outside Europe of particular importance. The first is that it will apply to processing of personal data anywhere in the world, for example, to a research project in Asia, if the processing is taking place in the context of an establishment of a controller or processor in the Union. In practice, what this means is that there should be a sufficient link with a European research entity, for example. So, for example, if research is being directed by an institution in Europe, but carried out elsewhere in the world, that processing is likely to be governed by the GDPR. The second element is that if the processing includes the offering of goods or services, and this would include a direct-to-consumer genomics service or perhaps a health app to individuals who are currently in the European Union, the GDPR will also apply to that activity. So it could capture companies and other bodies around the world. I just want to run very quickly through the general requirements. I don't think I'll do a brilliant job here of going through all the principles, rights, and obligations. So please look at our report for some of that detail. But there are essentially a few ways the regulation breaks down key requirements. First are those general principles, which again echo what was mentioned at the outset to a degree, but they are further substantiated in the GDPR through a range of rights and obligations that are more specific. So there are rights to information, rights to access your data, and then qualified rights to delete your data, etc. One of the important elements here is that you must have a specific legal basis for processing personal data. And perhaps differently to some laws around the world, consent is only one of these potential legal bases. And the same applies for what is known as the specific category data, which, as was mentioned earlier, includes genetic or health data. And here a further condition must be met, and that may include explicit consent, but there are other options as well. One other option is for scientific research. So there are various elements throughout the regulation which aim to create a more liberal regime to a degree for scientific research. But that success is mixed in implementing that. It often relies on member states to incorporate their own provisions in their own law for scientific research. So it's not a uniform application across Europe. And there is also debate about the interpretation of the scope of some of the scientific research provisions too. And so there remains some scope for variation between European countries. So I think just wanted to pick out a couple of general challenges before getting into the kind of cross-border international transfer issues. But these are the general challenges I think arising in genomic research. The first is, as mentioned, when dealing with genetic and genomic data, they are generally viewed as highly identifying. In fact, there is indication from the European Data Protection Board, which is the authoritative central guidance board relating to the GDPR, that they may always be personal data. And of course, they're subject to a higher protection as special category data, but also associated health, phenotypic or metadata may also be within the scope of the regulation in a way that wasn't previously expected by many. And this is because data which have been pseudonymized or coded, where identifiers are taken away and kept separately from the data, will also generally be included in the scope of personal data. Once that's the case, then a range of challenges apply, which we found in our work largely relate to complexity, uncertainty, and ambiguity about how this general regulation should apply in a very specific context of genetic research. And this has given rise to significant attention in scientific and general literature and in the media. But what I want to focus on in the short time I've got really is the particular problem at the moment around international transfers of data between the EU and also the UK and other third countries and international organizations. And this is because Chapter 5 of the regulation sets a specific regime for these transfers. It's important to note that these rules are in addition to all the other requirements of the GDPR. And it's in essence, what is required is that a specific legal mechanism can be found to legalize the transfer of data. And in passing, a transfer is also interpreted very broadly here. So it doesn't just include sending data, but it also includes making data accessible, even in the form of remote access to data. So in Chapter 5, there's set out a hierarchy of mechanisms, beginning with what's known as this adequacy decision, a decision by the European Commission that the recipient jurisdiction provides adequate level of protection of personal data to receive personal data, which 14 jurisdictions are currently recognized as providing. Below that, there are some safeguards which may be relied on, and these are often bilateral between the parties, so they include binding corporate rules between bodies in the same corporate group. They include standard data protection contract clauses. There are also some untested methods, such as an approved code of conduct or certification scheme. But if these don't work, then you may be able to rely on some limited exceptions or derogations. And these include a more limited form of consent. It includes a specific and quite narrow definition of when a transfer may be necessary for reliance in performance of a contract, and also public interest. Then there is one last element. If nothing else works, it is possible that for non-repetitive one-off transfers, a compelling and legitimate interest may suffice. But there are difficulties with all of these mechanisms. So the first with adequacy is that there are very few in place, and sometimes they only apply to a commercial sector, for example, so bar public sector research bodies from taking part. Then the safeguards can be extremely challenging. For example, the standard contract clauses may not be something that can be agreed to by public authorities or public research institutions around the world. And this is notably the case in the United States, where domestic legal provisions prevent bodies from agreeing to indemnification or other essential elements of the standard contract clauses. Some of the other safeguards are currently untested, but may be promising. And then the way that the exceptions, as they're known, or derogations, are interpreted is extremely restricted. The European Data Protection Board emphasizes that these are exceptions to the general rule, and in general, they shouldn't be used for regular or ongoing transfers. And I'm just noting there that the consent here, echoing what was mentioned earlier, must be highly informed and very specific to the actual transfer itself and the potential risks involved. Overlaying all of this, and where I was trying to get to fairly quickly, is a recent development. And this relates to the general rule in Article 44, which has been reaffirmed by the Court of Justice of the European Union in a series of cases on EU to US data transfers involving Facebook, the 𝐏𝐸𝐵 cases. It's affirmed that the transfers should only take place where a controller is satisfied that there is an adequate or essentially equivalent level of protection in the receiving jurisdiction. The courts emphasized that this is a really high standard, which includes an assessment of whether the fundamental rights and freedoms of data subjects are protected in accordance with the European Charter. And this causes particular challenges for transfers to countries with potential state surveillance of data, as was found to be the case in the United States. So when national security agencies are able to access that data. So for this reason, in the 𝐏𝐸𝐵 2 case, the court invalidated the EU to US Privacy Shield adequacy agreement. The court has essentially ruled that there must be an essentially equivalent level of protection present in a recipient jurisdiction. And this means that there has to be oversight of national security, access, or potential effective remedies for data subjects if their data are accessed unlawfully. And the consequences are both initially for the European to United States agreement, but also are that there are now potentially some supplementary measures that may be required or used to safeguard some transfers. But that everything in this chapter 5 has to be viewed in light of the very high standard of the European Charter. And that means currently we are in a slight limbo in relation to European to United States transfers, but also in relation to the rest of the world, because it is not entirely clear what level of protection may be adequate. So there are supplementary measures that have been suggested by the EDPB, but they are highly technical, and really the emphasis here is that only full encryption or maybe very secure multi-party processing may be sufficient. And even in relation to the COVID-19 pandemic, the approach of the board has been that exceptional measures may be used currently, but not in the long term. And scholars have cast significant doubt on the existing adequacy decisions between the European Union and other countries around the world. Others have emphasized that perhaps the only real successful approach presently is to use multi-party computation, really advanced forms of encryption like homomorphic encryption, but their application in the genomic research context is currently unclear. And there have been a range of calls, therefore, for solutions, both in the short and slightly longer term. There have been calls for new and context-specific standard contract clauses that researchers can use, in particular that public bodies around the world can sign up to. There have been calls for clarification and potentially new mechanisms for transfers of data in research in the public interest. There are also multiple efforts underway to explore the development of codes of conduct as potential transfer mechanisms. But these are all currently, untested, and it's yet unclear what a successful code of conduct would look like in this space. And then more fundamentally, there are calls for specific, essentially, adequacy decisions that are purely in relation to health or scientific research between the European Union and other countries. So in conclusion, I think the key challenges for international data sharing at the moment relate to uncertainty about some of the fundamentals, and that applies across the whole range of the regulation, but in particular to the key provisions around international data transfers. I think the upshot of this is a tendency towards greater data localization, and potentially, if technical measures can be found, then more limited forms of analysis, but query whether this may be harmful to genomic research. I think in the longer term, there is the prospect for genomic or research communities to develop or advocate for their own measures or codes, but this will take some time. And the other important element, I think, is that we need to watch the space in terms of global convergence and whether this could help address some of the mismatch between EU laws and the rest of the world. Thank you.
Okay, thank you so much, Dr. Mitchell. So as you see, Dr. Mitchell's expertise is clear, given that he has, very brilliantly summarized and discussed two important jurisdictions in less than half an hour. So no, even less than that, 15 minutes. So, thank you so much again, Dr. Mitchell. So, well, for those in the audience from Hong Kong, if you're wondering why I haven't said very much about the transfer of data, international transfer in particular, is because we do have in our statute provision on this. That's section 33 of the Personal Data Privacy Ordinance, but it has not yet come into operation. So, so in theory there, but otherwise, not quite there. Well, given that it's not being implemented. So nevertheless, the Privacy Commissioner has issued guidance on section 33. So for those who are interested, I'll put this in the chat. You're welcome to look this up. So this document speaks to a number of requirements that are very similar to what we've heard from Dr. Mitchell in his presentation. Now that said, it gives me great pleasure to introduce our final speaker for today, another very close friend of the center. So for all scholars working in the field of genetic research, particularly on the ethics and legal fronts, you'd know Professor Yann Joly's work. So he has published extensively on the topic of privacy, on data sharing, on genetic research, genetic discrimination. He's currently leading a project on a global observatory on genetic discrimination. So as you'd see in the write-up, Professor Joly is Research Director of the Center of Genomics and Policy at McGill University. He's with the Department of Human Genetics at the Faculty of Medicine. So it's over to you, Professor Joly. Thanks very much.
Thank you very much, Professor Ho, and it's such a pleasure to be back. I would love to be back in person, but we'll have to wait a little bit for that. If you can enable that, the sharing of my PowerPoint, Calvin, I'll be delighted to start my presentation. And thanks again for having me. And what I can say while I'm just starting my slides is that this presentation is going to be a little bit different in the sense that I'm not going to focus uniquely on law. I would even say it's probably going to be more about ethics and interdisciplinarity than it's going to be about law. And I'll explain why today. So let's start with two ways of saying the same thing. So you got the really philosophical quote from Plutarch, for those of you that are into Greek philosophy, and you got the more recent one from one of your compatriots. They're both saying basically, everybody makes mistakes, but we really have to learn from our mistakes. And that's one thing that Canada has failed to do, sadly, in the context of a pandemic. And this is the story I'll be telling you today. And I'm sort of using that story as a case study to demonstrate the limits of our data sharing capacity in Canada. All right, let me get this started. So I do have to make a small disclosure at first. The story I'll be telling is a story I was a part of as the chair of a data sharing, a national data sharing committee, I was basically responsible for facilitating the sharing of both human genomic data and pathogen genomic data. The committee was formed at the end of 2020, so a little bit after the start of the pandemic, and I stayed in function until March 2022. And also I was part of the executive team of a portal where the data was, some of the data was shared. But what I will say today are my own observations on the situation. So let's start by my starting premise, and you're free to disagree with me. I love when people disagree with me and we can have debates over these things. My premise is simple. Broad access to genomic and health data benefits health research, and health research in turn will lead to better quality healthcare. Second premise, when facing a global pandemic, there's a need to facilitate and to optimize research to improve public health response. So we need to react more quickly when there's a pandemic. Everything goes fast. You know, disease go global in 24 hours, right? So we need to be able to respond quickly. We saw our COVID variant evolve very quickly. So in order to do that, we must be able to capitalize on research extremely rapidly. And finally, back to legal territory, health is a human right. And I would argue that health data is probably a global public good, although some people would disagree with me on that part probably. So now that we've put in my premises, let me talk a little bit about the Canadian data sharing context. And we'll focus mostly on the public health context, but also on the researchers as well in genomic centers. So the way that the information is shared is usually, and I'm talking about the genomic data that is collected from patients. So it can be, again, their genomic data of sick patient that are sick from COVID, and it can be also the genomic sequence of the virus. So this is collected, everything is separated in Canada. We're a federation of provinces, which complexifies everything. So everything goes by provinces. There's a public health lab in each province that is responsible for collecting the data at the provincial level. And then there's a national microbiology laboratory that is there to help coordinate the action of these provincial labs. And so basically they communicate to the NML, this national laboratory, the information on a need to know basis. And then NML will share it with the 𝐠𝐴D portal if it is viral data. So viral data is information that if it has been de-hosted from any human genome, it doesn't meet the requirement of most privacy standards, and I believe the GDPR as well, although Colin, you may correct me on that, but it is not, you cannot identify somebody from a viral sequence. And of course, virus don't have any privacy rights that I would be aware of. So that's why that information can be communicated freely. In the case of human genome data, it's more complicated. There's no single point of access. So the NML, the National Laboratory, does not provide access to this information for research. And we'll see that there are some collection sites, but the standards are inconsistent in terms of what you need to do to access the data between those sites. And let's talk a little bit about our privacy laws. They're a bit of a mess right now because we're in the middle of a privacy law reform. The reform is intended, and again, our privacy laws, we have privacy laws that are sector specific and province specific. So that means we have over, I would say, probably 20 privacy laws, depending on the sector and the provinces in Canada, and plus some laws at the federal level. And a lot of these are being currently reformed, which add to the complexity level. Again, the idea is to be sort of equivalent to EU so that we can share data with Europeans at some point in time more easily than now. All right, so we launched an initiative to help improve genome sequencing and sharing in terms of pandemic. The initiative was launched in 2020, and you see it was a $40 million investment at first, but it got Canadian dollar, but it got larger as time and need increased. And you see what the mission was. In the case of the viral sample, the idea was to sequence up to 150,000 viral samples and to share it with the international community and with the national community to facilitate research. In the case of human genome, it was a little less ambitious, up to 10,000 patients, along with we would have their whole genome sequence diagnosed, along with metadata information that would help interpret it. And there were several funding program and scheme that were collaborating on this. Sadly, we did not put sufficient, I would say, pressure to also be inclusive in this data collection and sharing process. So a lot of traditional marginalized group were sort of left behind. I'm talking about indigenous community, for example. So it's just that it's a complicated process to get that data, even more so than regular health data, and we were just not quickly, we didn't develop our practices quickly enough to make it possible this time around, sadly, at least not at a large level. So here's the situation after a year and a half of pandemic. It's pretty pathetic. We see that Canada, although Canada has actually sequenced and released a fair amount of genome. I mean, we're ninth in the international community, and I'm talking here about pathogens, so viral sequence data, but I'll pass on to human data in a second. The problem is we've been so slow at sharing it. And there we rank in 86th, 83rd place. So it's really the timing. And the timing, if my memory serves me right, you can see it on the other diagram, which I apologize is very small, is around 80 days to, so from collection to depositing the data in the international database, it took about 80 days on average, which is way too long compared to the United Kingdom, which were, if my memory serves me well, again, something around 15 days at that point in time. So very slow sharing of data that is not raising any privacy issues because it's not personal data. When we talk about human genome sequence, we were doing even worse. At the time, we had a portal and plan that we wanted to develop to give a central access to human sequences, of course, controlled access to meet privacy requirement. We were aware of that, and for with consent. But there was basically nothing open after a year and a half of pandemic, so really not looking too well there. And also the importance was to be able to link both the viral and the patient data in order to do the most kind of interesting health research. Again, that was not possible at that point in time, just too complicated. So why didn't it work out? It didn't work out because of four main issues that we identified fairly on, or at least around that point in time, we knew these were some of the major issues. Canada is a federated, as I mentioned, country, which means that everything is decentralized, and there's a fair level of competition rather than collaboration sometimes between the provinces and between the health labs. And so it was really difficult to coordinate things and to make everybody be part of a same team in a way. That was the biggest challenge. So very often we think that when data sharing doesn't work, and I think if there's one important lesson to this talk today, is we think that it's because of data privacy laws. I can really tell that in the case of the pandemic for Canada, it was not about data privacy laws, or at least not real problem. There was a perception, and that's what I mean by data privacy concern. Very often laws were invoked as a reason not to share, but when we actually looked at the laws, they were not preventing the kind of sharing that we were trying to enforce. Lack of capacity, of course, genomic at that level and to that extent was something that public health was not ready for. So we had to really invest in building the capacity. But it was complicated because also they insisted on doing everything from the inside. And so not having somebody from academia come to help. No, they wanted to do it themselves. As I said, it's this concept of it being difficult to work in a team and perceived lack of incentives. So Calvin has talked about open science, open source, and how great this is. And like him, I'm a big believer in open science. However, for it to work, you wish that people would do things out of altruism all the time, but incentives are key there. So that was one of the other reasons why things could have worked better, is that there was a perceived lack of incentive, the what's in it for me if I share. So this is the response that 𝐏𝐿, so that Canadian initiative for data sharing. This is what we decided to do as a response, so that the data sharing work group was created that I shared. And then there was an increase in funding. So all of a sudden it became clear that, okay, we need to spend money on policy, on data governance, if we want the data to flow and if we want to be able to share. Investment in capacity building. We created a VirusSeq data portal, so a Canadian portal to share the data. Basically, what the portal does is it does the same thing as the international database 𝐏𝐫𝐸𝐧𝐷, but it's even more accessible. In terms of data on 𝐏𝐫𝐸𝐧𝐷, you have a license that you need to agree to in order to view the data. For the Canadian VirusSeq data portal, you can just go right ahead and view the data. So it's more simple. Again, we're talking about non-personal data. We're talking about viral sequence data for this portal. A second portal was created for the personal data, and again, that was under controlled access. And finally, we developed a data sharing roadmap identifying sort of key challenges and what needed to be done about them. So we also identified some avenues for legal reform. So mostly the problem is that public health laws, again, sector specific, so public health benefit from exemption, things that they don't necessarily need to do in time of pandemic. They can actually collect data from people, from sick patients without consent, and they can use it for public health purposes in times of pandemics. But what's a public health purpose? Is research a public health purpose? Well, depending on which law you are talking to, the law would say yes or no, or depending on the way that it was interpreted by privacy authorities in the different Canadian province. So basically, our first suggestion was that a reform be carried out, and that this was really meant to clarify the content of the law and of the public health exemptions in the law, and also that some documents be developed to guide people as to what were appropriate anonymization and stewardship practice. We also wanted our public health authority to shift more to a data stewardship model, meaning that before it was more about either ownership or custodianship of the information, kind of like we're owning this information, we're responsible for it, therefore we're not going to share it with other. Now we're more thinking of a model of data stewardship where really you want to foster the information, we want to use it for the common good. So that was also part of this proposition for reform. Quickly, as I'm moving on to the second part of the presentation, Here's what the results are now, much more closer in time. So if you look at March 2022, we actually went, so the delay that I mentioned at first was 88 days to deposit data in 𝐸-SATE from the time of sequencing to the time of deposit. Now we're at 27 days from the time of sequencing to deposit. So it's a big increase. I'm not one to shout victory, and I'm definitely not shouting it. I think we reached the middle of the pack at this point, but it's always better to be in the middle than to be at the back. I just wish that we would have been much faster to do this, because everything's about time in times of pandemic. 𝐸𝐸𝐶, which is basically the part of 𝐏𝐿 that was responsible for patients' information, finally opened for business in the fall of 2021. Again, too slow to my own taste. Now they have over 7,400 human genome sequence, and the metadata is also starting to be present on the database. And if you're interested, it's under controlled access, so you need to agree to a data access agreement and you'll be able to view this data. So as a result, what can we say? I would say that from the common experience of 𝐸-SEQ and virus-seq, we went from a slow start to joining the middle of the pack. So again, it's a positive outcome, but why couldn't we start at the middle of the pack? That's what I said in my first slide when I spoke about learning lessons from the past. Canada has not a really great past of response to pandemic. And so we should have been aware, we should have been ready from the start of the pandemic, like other countries like the UK were, and be much more responsive. We, as I mentioned, issued a lesson learned policy brief. I'd be happy to share it with people upon request. It's still not public, not because of my will. I would love to share it more, but I'm still waiting for approval. Again, everything takes time in Canada, so waiting for that to happen. Some of the things that are addressed in the lesson learned policy brief, viral sequence and minimal metadata. So how can we make this faster? What is needed so that the system be really well streamed? Data privacy legislation. So what is needed in terms of change to the data privacy legislation? I've mentioned some of the changes that were needed, but we go more in detail, of course, and I'd be happy to go more in detail if there are questions. Data stewardship, I talked about it. Attribution and accountability, again, that's the what's in it for me if I share factor. Infrastructure, data sharing committees, etc. It took a very long time for all our constituents to accept the lesson learned. Again, it's difficult to tell people that they've not performed optimally and that things can be, done to improve the performance and to have them agree to this, but we finally did it. I wish I could say, problem solved. Not really. I think we've really improved, and that's the good news during the pandemic. But are we going to be able to keep what we've gained during the pandemic and start at a better place next time, or even continue improving between pandemics? I can't say at the present time that this will be the case. This is how difficult the situation is in the Canadian framework. And I think that this was my last slide, yes. So thank you again for the invitation.
Okay, that was brilliant. Thank you so much, Professor Joly. So we do have time for Q&A. So you're welcome to, participate directly. If you just raise your hand so that we know that you have a question, you're welcome to present that yourself in person, either with the camera on or not. Or alternatively, you're welcome to put your question in the chat. So quite a few options. Please do feel free to share with us. As I've mentioned, this setup is meant to facilitate interaction. Please do feel free to do so, especially since we have got eminent experts with us from 3 different jurisdictions. So while we wait for questions, I do wonder, a question for all members of the panel, whether you think we are approaching some kind of normative convergence in thinking about data protection. So data protection, first of all, and then sharing in general, and then following that, right, sharing specifically for research purposes. So obviously this would be the common good kind of reasoning that would apply. So what do you think, given that as we see two of the largest economies in the world, of course, we're talking about Europe and China, having essentially similar provisions on data protection. I'm not sure about the situation in Canada. It'd be good to hear from Professor Joly on this point. I am even less certain about the situation for Professor Joly's neighbor. Of course, that's the US to the south of Canada. What might follow, thinking about the fallout from the 𝐏𝐶𝐬𝐵 decisions that Dr. Mitchell mentioned. So why don't we start with Dr. Mitchell and then Professor Joly and finally, of course, Dr. Zhang in terms of the more recent developments on mainland China. So Dr. Mitchell, over to you.
Thank you very much. Thank you. I think that's a fantastic question, which I have been pondering whilst thinking about this talk. I mean, we've had some excellent examples of what appear to be regulatory convergence in data protection space. It was beautifully presented by Dr. Zhang in terms of the, the echoing of the GDPR in the Chinese new regulation. And we've seen around the world some other legislation being brought forward inspired by the GDPR, clearly, including in California, and I think in Oregon and other jurisdictions in the US are taking some of that forward. But I think there is a caveat to some of this. So I think we're perhaps seeing apparent convergence in terms of the nature of the structure of a regulation or the essentials of the principles and the rules it set out. Perhaps that's slightly unsurprising, given even the European position rests on international policies and instruments like the OECD privacy rules. There is no single global human rights treaty, for example, that hooks to this, but there are influential ones like the Council of Europe's Convention 108, which has been updated in recent years. So I guess there is a common inspiration. But I do think there is a caveat, and that relates to the thing I left out of my talk entirely, really, which was the profound importance of the backdrop, the ethical framework, the cultural framework, the policy framework in all of these different countries. And I think that means that despite the apparent similarities between jurisdictions, it still remains open, as we've seen from the European court's perspective, to go beyond that kind of superficial analysis and look very deeply at the nature of protections, safeguards, etc. in a regime. So I think that for me still gives pause for thought in terms of how successful alignment may or may not be from a context of a researcher. So I just paused there, but I know there's also, there are concepts, for example, Professor Barthenopers and colleagues, very eminent in this field, talks of normative interoperability in terms of the kind of governance arrangements in genomic research. So I think not all is lost if it's possible for consortia and other groups to navigate some of these distinctions and dissimilarities through their own internal processes.
Thank you so much, Dr. Mitchell. So Professor Joly, what do you think?
I think interoperability is a great objective. I do think we're moving in the right direction. I do think that a perfectly uniform framework between the different world countries is not really a possibility and in the near future. And again, I'm not sure this is something we ought to tend to do. I think that it's great. The model passed by the GDPR is, I think it's well received in terms of, helping us moving towards a more contemporary framework that really take into account AI and all these new ways that exist of sharing information, of keeping information, etc. So I think it's great to have this model to sort of update the laws of the various countries, but I think that, yes, we must be able to realize that it is also not up to one region of the world from a legal standpoint to dictate their normativity, on the global scale. So yes, this is what I think we're going to see. And I think the impact on data sharing is that, and we've lived through a period of great uncertainty when the GDPR was really initially adopted. What do we need to do to comply? How are we going to share data? But we see now that data is continuing to flow. Sometimes it's more complicated. And so what I'm saying is really, I think that within the next 5 years, our systems should have adapted to this new reality. Again, not a uniform framework, not even perfect interoperability, but a general good global flow of data. And that will be done in a way that is private and secure. I do want to also mention the work of international organization. You're aware, Calvin, of the great work of the Global Alliance, which is basically an international association that's dedicated to developing tools and policies to make it easier to share data on a global scale. And again, maybe to close, it's not all about laws and policy, although they will bring you somewhere, but it's also a question of culture, of ethical perspective that we need to consider. Because if the culture is not ready to share, even though the law might allow it, we're not going to see it happen as much as we'd like to see it happen.
Thank you so much, Professor Joly. Great points there. So I'm just going to put in the chat for people who are not familiar with this setup, right? The Global Alliance for Genomics and Health. You're welcome to look this up, and there are some very helpful resources. We do have a question from Joshua. Hi, Joshua. So is your question specific to Professor Joly's point, or is it?
No, it's in general.
General. Okay. So why don't we invite you to present your question, and then we'll hear from Dr. Zhang first, also in response to the earlier point on regulatory convergence, if we can think of that.
Just a quick question, and it's inspired by lots of the discussion today. The discussion is wonderful. Thank you very much for all the speakers. But actually, one of the things that Dr. Joly mentioned that really sparked my interest. So I'm a bioinformatician in Hong Kong U. I spent a lot of time dealing and analyzing genomic data, and I was inspired by the thought that, well, viral genome, there's no privacy issue. But remember, the viral DNA does come from an individual human. So therefore, the key is not whether it is DNA or not. It's actually whether it's derived from an individual, and this is a DNA that could potentially one day, not necessarily now, based on information that may be available in the future to identify a person, because fundamentally it's an immutable feature of that individual. But what if we are dealing with human genetic data that come from, say, cancer, a tumor in which the genetic makeup is mutable? In fact, that is kind of what we see a lot. We have fast evolving a tumor that have huge amount of somatic mutation in which the genetic makeup is very different from otherwise a non-cancer genetic a makeup from other part of their body. Would that still be a problem? Both ethically and legally. I'm just very curious about that.
Thank you so much, Joshua. Great point there. So why don't I invite Dr. Zhang to speak to this first? But I'd just like to very quickly ride on Joshua's very insightful question, right? To say that as far as viral sequencing data is concerned, and Professor Joly will know this, as well as some of our colleagues in our medical ethics and law course, right? The whole discussion of whether digital sequence information should fall within the purview of the Convention on Biological Diversity. And if it does, of course, then there will be consent requirements, and there will be contractual requirements in terms of the transfer of such data from the originator country to some other third-party user. So basically it translates to, in one sense, for researchers at least, more bureaucracy, more paperwork, but where originating countries are concerned, it could be well, fairer access and benefit sharing, or greater assurance of benefit sharing. So, so Dr. Zhang, is over to you. I'm sure our Chinese colleagues would have encountered this, and a lot of exciting developments on the mainland. I think it's also important to highlight, for those who don't already know, the central government's commitment to scientific progress is very clear. So we are going to see continued investment and support in this space. So grateful for your thoughts from, of course, one of the key research setups on mainland China.
Thank you, Kevin, and both many thanks are due to Professor Yann and Colin. Yeah, I do agree that we have certain kind of common sense or consensus that data sharing is for the common good and for the shared better future. So we have certain kind of consensus. So far, I think in China, for many people were felt frustrated how to do it, how to make the data to be shareable. So I just do very agree to echo Professor Yann's point that how to make such kind of more incentive. And another obstacle may be the capability or capacity for sharing. So many investigators or research teams in China would like to share their data. So, but according to our experiences, many investigators felt so frustrated because we are lacking maybe certain kind of infrastructure or certain kind of support. So that's one, I think one of the main obstacles for make the data sharing more feasible or workable. Another thing is take into consideration the different research capacities. We need to, I think, develop certain kind of mechanism to make sure all the credit are equitably attributed to the contribution who were made by individual research team or investigators. I think this is one of the most important and certain kind of incentives for such kind of data sharing. In general, I think we are in the way to trying to figure out how can we make more equitable and responsible data sharing.
That's brilliant. Thank you so much, Dr. Zhang. So Professor Joly, it's back to you. Any response in particular to what Joshua has raised? And but
yes,
before you reply,
very timely.
right?
Go ahead.
Yeah. Sorry, I was just going to say, Dr. Mitchell, may I just probably look into the chat? I think there's a helpful comment from another colleague of ours, Kang Hui. I think he's in the audience. So sorry, Professor Joly, over to you.
Good. No, it's a fantastic question, because it shows again that, you know, even though the law may be somewhat harmonized or agree on some point, the devil is also in the detail of, okay, this is what the law says, but the law doesn't exactly tell you about cancer mutation and whether those should be shared or not. It's a question of interpretation. And what's great though is that the criteria, the broad criteria, is this criteria of reasonableness, of being able to re-identify the data, if I simplify. So basically, how reasonable is it to think that somebody having access to that genetic information would be able to link it to a human host? And of course, then comes the question of what's reasonable, what's unreasonable, and that is to be analyzed on the case per case basis and looking at the jurisprudence, the case law, basically. So that's why it's complex, and it is also perspective. So you also have to have a perspective look and think about, okay, if in the near future it would be fairly easy, then again, that should be protected more. And that's why right now, at this point in time, I do think that there is a consensus that, and again, I'm not talking to the Convention on Biological Diversity, because that brings up even other measures which are also linked with ownership and benefit sharing that Calvin, you were speaking to. But I'm talking from a purely privacy standpoint. The fact that the sequences are deposited on 𝐸-𝐳 really show that in most countries, if these viral sequences have been properly de-hosted, if the metadata that accompany the sequence is really succinct and also does not help in re-identifying the person, then these sequences are not considered personal data and can be deposited in a fairly open database. But again, for cancer, the kind of cancer mutation you were talking about, that's very different. And you're absolutely right that some of this information would be much more complex to share and raise privacy issue. And last point, I think that your question about the application of the Convention on Biodiversity is super relevant, Calvin. I think right now, and also we have to consider when talking about this, about the attempt by WHO to come up with a new agreement to simplify this process. And they also have adopted an agreement to facilitate resource sharing in times of pandemic that we have also to consider. Which makes it a little bit more easy than the Kyoto Protocol and the Convention on Biological Diversity, because you really don't want the process to be so complex. Again, everything has to work fast in time of pandemic. It's my mantra.
That's brilliant. Thank you so much, Professor Joly. Now it's over to Colin. So Dr. Mitchell has put in a very helpful response in the chat, and now would like to invite him to speak to this and also some of the other points raised in the discussion. Dr. Mitchell, over to you.
Thank you very much. Yeah, I mean, I don't have huge amounts to add. That to which Prof. Joly has already mentioned, I think covers it really well, which is that, in the data protection law terms, the standard of potential identifiability is, a contextual risk assessment. And European case law has emphasized that this is relative to the, to the context and the parties and the information available. And I think the question raised earlier regarding pathogen data and other forms of data that don't obviously seem identifying goes to this really difficult boundary of what is and isn't identifiable. And unfortunately, this is a matter for continuous ongoing debate and assessment by those controlling the data, and that's part of their requirement in data protection law, to have an eye on the state of the art and the availability of additional information that could help identify an individual. And so that's meant over time things like functional genomic information has come to be viewed as potentially identifying, as scientists have demonstrated the ability to do so, and combining that with, as I say in the chat, a relatively expansive view of what we mean by identifiable data or identifiability does mean that there is the potential for, at least, if not the data itself relating to, a virus, but the data plus the availability of metadata or other information about host vectors, etc., could lead to identification. And that's unfortunately just a really difficult matter for contextual risk assessment. I think also perfectly covered was the issue relating to biodiversity, which was a recent conundrum raised with us. We haven't focused very heavily on the pathogen data in our work. We've looked very much at the host data, but we appreciated the challenge that a number of nations around the world are viewing pathogen sequence information as subject to the convention and the and the Nagoya Protocol and the challenges that gives rise to. whether that's appropriate, whether it's appropriate to view that form of information as part of our biodiversity, I have mixed views on. But I can completely understand that the overriding context is one where certain nations and communities will be saying, where's the equity if we provide this information in terms of measures and responses that can help us and our population with the pandemic. So I think it's a very vexed position, as was already outlined nicely.
Thank you very much, Dr. Mitchell. Certainly very helpful there. And thank you so much for those references as well. I'd like to check with our participants whether you have got any questions to raise. Joshua, I do hope that your question has been responded to, but thank you so much for sharing.
Thank you very much.
Yeah, love to hear more about your research as well. So please do get in touch, or stay in touch for that matter. Thanks very much.
Absolutely. Thank you.
Thank you. Anyone else with any questions to raise? You're welcome to present your question in person, or if not, put it in the chat. Last call. I am, well, just in case there's no further comment or questions, I'd just like to end off by seeking the thoughts of our eminent presenters on how you'd see data sharing as moving on. Is it going to become a more complicated world for researchers? Because it seems as though it's going to be a very contractual affair. So you either need to, or you generally need to get consent of the data users, or for that matter, have contractual provisions in place. But I do see another one of our colleagues with potentially a question or perhaps a comment. So Suresh, over to you. Good seeing you in this forum.
Hello, Professor. Actually, my question is a follow-up to what you just asked. My question is that, since the data protection regime is becoming more stringent with respect to the kind of data we take, especially with respect to research, and as Joshua mentioned, that there are going to be mutations and different forms of data identification. Don't you see the process being a little more and more bureaucratic? And as data localization becomes more prominent, isn't it going to cause even more problems with respect to research? Because I think there is a larger understanding in the scientific community of sharing information, and I think that's exactly how research and development has prospered over years. And expecting scientists or anyone in the field to have that kind of knowledge, right, with respect to what exactly the provision is and the compliance of these provisions, wouldn't it waste a lot of valuable scientific time in just understanding of what to share and what not to share? I'm just curious to understand this. Yes.
And that's really helpful. Thanks so much, Suresh. So, let's see. Why don't we start from Dr. Mitchell, followed by Professor Joly, and then, of course, the person with the last word will be Dr. Zhang, closest to us. So, yes, Dr. Mitchell, over to you.
Yeah, thank you. Another brilliant question. I think it probably is, to some extent fair to say, as you also said, Dr. Ho, that, that we are heading for increasing bureaucracy and contractual arrangements. I suppose what we've got to remember is that this is a contrast with maybe previous positions, which were much more ad hoc, less well governed, and perhaps involved the sharing of data which were assumed not to be identifying, and we'll touch, back onto that issue of anonymization again. But part of the, the development of the regulatory structure is aimed at improving that situation and of preventing potential harms, breaches, and of safeguarding the data and the data subjects behind them. And that's, increasingly important as ever burgeoning volumes of personal data are produced and processed digitally. So there is a flip side, which is the protection element. But I think it's true to say that in terms of navigating the complexity, probably the most likely sort of solution and way forward is a greater sort of formalization and centralization, either around kind of research consortia and groups, or structures enabling and kind of holding data. So I'm talking of biobanks and other facilities in that regard. And in a way, we are seeing the development in a broader sense across data protection and data governance of sort of these intermediating organizations who themselves might perform a lot of those functions, have sufficient expertise, etc., etc. And I think the other trend that leads that to be more likely in going forwards is the computing power that's going to be required and the immense technicality around some of the processing of data as we develop that. And that's best done by ever centralizing, growing infrastructures. So I think we won't see so much of the individual researchers sharing their individual data set for good and or ill.
Thank you. That's really helpful. Those insights to think about and perhaps steer policy accordingly. So thanks so much, Dr. Mitchell. So Professor Joly.
Yes, what Colin said, that was great. I'll just add a little bit to it or pursue a little bit further. I think one concept that has come forward a lot in recent months is the concept of data federation. So the idea behind data federations is that you can, make your request from local site, say what you're looking for, even talk about the kind of result you'd be anticipating. And I'm saying this in very lay term. I'm sure bioinformaticians that are attending will know more about what I mean. And basically, so what you do is you never have your eyes on the data. The data stay at the local site. So I can be in Canada and then ask a site in the UK or a site in China, do you have these types of variants in your database? Can you see if there's a correlation? And they will only, again, answer me in terms of statistical aggregation of data so that I will never see for myself the individual data. So that's sort of an answer when things are getting too complicated and too contractual. Of course, you don't want to do it if it's unnecessary, because the more data you can see, the richer the data is, the better it is ultimately for research. But there are going to be these situations, especially right now while we're still sort of in a transition and adapting to the new legal framework, where things are just going to be too complicated. And that's where you have this solution of shifting to this federated model. And there are more and more technologies that are now able to work in federations, making more and more data accessible to researcher in that way. So that's sort of the positive news if we want to avoid the whole contractual scenario.
To be sure, it won't be free, I presume.
No, I mean, open science, I would not. I actually think that there will be a free model. We have some in Canada already. Again, the Global Alliance has developed, some data federated model of access, for example, to look for cancer variant. So I'm sure there will be also private one, again, for sure, if there is potential a lucrative scenario, you can see that the private sector will go in that direction. But I do think that, again, the open science movement will also go in that sphere for sure.
That's brilliant. Thank you so much, Professor Joly. And of course, very interesting developments to watch on mainland China, because, just from a legal standpoint, I'm really curious how arrangements like data federation, data trust, and similar kinds of data sharing platform will come about, because I imagine it to be quite a complex, not just legal exercise, but also regulatory one. So I do wonder what your thoughts are, Dr. Zhang, in response to thinking about data sharing moving forward, whether it's going to be more bureaucratic, more costly. It's certainly going to be a time-consuming process, you've already mentioned, as we sort out the rules, isn't it? So over to you, Dr. Zhang.
Thanks, Kevin. And I do agree with Professor Joly and Colin. Yeah, I think this may be in the process of regain our trust in China and internationally. So maybe currently we can see the legal system or the regulatory requirement became more complex and time consuming, but I do think it's temporary. So we may have some back and forth to figure out a better way or more efficient way to make sure that responsible sharing and responsible use of all of this data. So just a very quick response.
Thank you so much, Dr. Zhang. Certainly very helpful, and we will be closely following developments on the mainland. So having said that, I'd like to again thank all of the participants. For those in Hong Kong, it's a Friday night. So really grateful that you're spending time with us, particularly when pandemic restrictions here have been lifted. So we have been grappling with the fifth wave for some time. So it's wonderful that that the situation is improving here in Hong Kong. So I'd like to thank our wonderful speakers, Dr. Haihong Zhang at Peking University, Dr. Colin Mitchell at PhD Foundation, University of Cambridge, and of course, Professor Yann Joly from McGill University. So we'd greatly value feedback from everyone. This is likely to be the first of a series of webinars that we will have touching on the topic of data protection in the context of biomedical research. So if there are any particular issues that you'd like us to look into, things that might be helpful for your work or things that might have come up in the course of your interaction with researchers or healthcare providers, please do let us know. We will be very keen to follow up on these. So let me take this opportunity again to thank everyone and to wish everyone a very restful night ahead for those in this part of the world, and a very pleasant day ahead for our colleagues in Europe and North America, or for that matter, in the other side of the world. So with the benefit of sunshine at this point. So well, do keep in touch, and we look forward to well, continuing discussions moving forward. Have a good night or good day ahead, everyone. Bye for now. Thank you.
Enjoy the weekend.
Thank you.